Be a quick summary on trusts, but before we go there, let's review the three basic estate plans that you have available. Number one is the do nothing plan, procrastinate, which we hope that you do not use because generally this will have you wind up in probate court. Number two is a will-based estate plan, and for information on wills, we invite you to go to the will video on our website. And the third is a trust-based estate plan, and we're going to talk about trusts right now. Trusts are very popular. We hear a lot about them these days. There's different kinds of trusts. Some are revocable, some are irrevocable. The one we're going to talk about here is a revocable trust, often known as a revocable living trust, a living trust, or an inter vivos trust. How's that for a bunch of different names for the same type of trust? When you create a trust, it's a legal document that is for you and your family. There is no requirement of filing any papers with the state or any other agency, which is very nice, and allows you to keep your affairs private. To set up a trust, there's three parties to a trust. On this diagram, we see the word trustor up at the top. The trustor is the creator of the document. And this is the person then it gets to dictate the terms that they want in their trust. The second party on the left is a trustee. The trustee manages the various assets that are placed into the trust, and oftentimes this is you. You've been managing your assets throughout your lifetime, and you will continue to do so. The nice thing here is that you will also appoint successor trustees or successor managers to manage the trust assets in the event that you ever became incapacitated or passed away. The third party to a trust is a beneficiary. This is the person who benefits from the assets in the trust. And since these are your assets that you put into them, you better be the beneficiary. And almost all the trusts that we create for our clients that are revocable, the client holds all three positions. They're the trustor who creates, the trustee who manages, and the beneficiary who benefits from the assets. In order to have the trust be operational, we have to put certain assets into the trust. So that's why you see in the center of the box here the family residence, maybe bank accounts, some stocks or other investments are oftentimes put into the trust so that they can be managed as a part of the trust. This trust is also revocable, which means that the terms can be changed at any time by you. So as life changes, your trust can change. Now, the magical component to a trust is that California probate law says that no probate is required on assets that are in a trust. So if we have a person that passes away, the idea of the trust is that the assets in the trust will not have to go through a court probate process. So that's generally good news to everybody. However, some clients then think that if there's no probate, there's nothing to be done in the event somebody dies with a trust, which unfortunately is not the case. There is something called trust administration, so we do have to administer things because death is obviously a very significant event, but we are not going through the publicity or the costs or the delays of a court probate. Most people I talk to do not want to be part of court, and that's why trusts are popular.